to the International Business and Law Academy. My name is Anne, and I would like to present on the subject of expropriation dispute resolution problems. First, we're going to discuss about a case study in order to understand the nature and function of expropriation. Next, we'll be finding out the troubles of resolving a dispute between a state and an investor. The case that we will be discussing today is between Republic of Nicaragua versus Standard Fruit Company. The facts are, since 1970, Standard Fruit, a wholly owned subsidiary of Standard Fruit and Steamship Company, had been involved in the production and purchase of bananas in Nicaragua. In 1979, the Sandinistas overthrew the government in Nicaragua and began efforts to assume closer control over the banana industry. After attempts to negotiate a new contract with Standard Fruit, which had stalled, the government issued a decree that declared the banana industry was to become a state monopoly. This meant that all plantation leases would be transferred to a new government agency, and all pre-existing lease, partnerships, and fruit purchases were nullified. Standard Fruit, interpreting this decree as an expropriation of its business, immediately ceased all operations in Nicaragua. In response, Nicaragua requested a summit meeting at which Steamship could sort out its differences with the Sandinistas. After 3 days of intense negotiations, Steamship signed a memorandum of intent that envisioned the renegotiation and replacement of the existing contracts between Standard Fruit and the government of Nicaragua. It also contained an arbitration provision that stated any and all disputes arising under arrangements contemplated hereunder will be referred to a mutually agreed mechanisms or procedures of international arbitration. Although Steamship, Standard Fruit, and Nicaragua all acted as though the memorandum was binding for almost 2 years, the implementation contracts were never finalized, and Standard Fruit left Nicaragua for good in 1982. Nicaragua claimed this action was a breach of contract and petitioned a U.S. District Court to compel Steamship to arbitrate the dispute. Steamship argued that the arbitration clause was too vague to be enforceable. So the issue here is, should the U.S. court compel Steamship to submit to the international arbitration? And those are the facts, and you know the issue. So now I would like to invite you to discuss about the case, maybe talk about the specificities, and apply some theories. So Ruby, please start us off. What is expropriation?
So, expropriation implies that the state uses the state's right to nationalize an investor's asset. In terms of international theory, there are different perspectives, such as global approaches to expropriation includes the view of, from the capital importing nations that they have sovereign power over both domestic and foreign investors. And whereas the view of the capital exporting nations would include a host nation's sovereignty must be balanced against the foreign investor's property right.
Ms. Guan, can you please give some specific examples of expropriation?
I can give an example about expropriations. When we talk about nationalizations, Vietnamese enterprise law affirms a nation may not expropriate foreign investments unless three basic requirements are met. For a public purpose, non-discriminatory, prompt, adequate, and effective.
Tran, can you please reconnect to the case, please?
Since 1970, the Standard Fruit, a wholly owned subsidiary of Standard Fruits, and the Steamship Company had been invested in the production and purchase of banana in Nicaragua. In 1979, the new government issued a decree that declared that the banana industry was to become the state monopoly. All plantation leases would be transferred to the new governmental agency. All pre-existing lease, partnership, and fruit purchase contracts were nullified. This is a violation of the investor contract, like nationalization.
John, please follow up on that.
Right. So in 1979, the Sandinistas overthrew the government in Nicaragua and began an effort to assume closer controls over the banana industry. So this appears to be a political violations affecting foreign investors. So theoretically, this is a political violations. The investor is always at risk of overthrown of the government by the people.
In order to answer the issue of the case, we should clearly analyze the problems that all parties have to deal with. We must clarify the roles of the government of Nicaragua. Hence, I suggest you to discuss more clearly about the terms of the contracts when renegotiating between Nicaragua and Standard Fruit and the performance of the contract. Please, Ms. Wan, can you please start us off?
After 3 days of intense negotiations, Steamship signed a memorandum of intent that envisions to the negotiations and replacements of the existing contract between Standard Fruit and the governments of Nicaragua. It also contained an arbitration provision that sought any end on dispute arising under the arrangements contemplated hereunder will be referred to mutually agreed mechanism or procedures of international arbitrations. This means the contract dispute must be resolved by international arbitrations.
That is correct, Ms. Wan. Ruby, can you please follow up on that?
So since Standard Fruit left Nicaragua in 1982, when a dispute occurs, Nicaragua claimed this action was in breach of the contract and petitioned a U.S. district court to compel Steamship to arbitrate the dispute. Steamship argued that the arbitration clause was too vague to be enforceable. I think that when international companies commit themselves to arbitrate a dispute, they are in effect attempting to guarantee a forum for any disputes.
John, can you
So I want to reiterate the troubles involving a dispute resolutions. So theoretically, in dispute resolution problems, there are multiple legal systems. So first, a private lawsuit must be brought before a national court. And second, the global conflicts involving more than one nation's contracting to simplify dispute resolutions. So global contracts frequently contains key provisions designated to reduce many of the uncertainties associated with the international litigations.
That is correct. And Turin, please follow up on that.
I repeat, when a dispute occurs, the two sides have the right to choose. Forums selection clauses which designated where the lawsuit are to be heard. Choice of law clauses which specified that the law govern any dispute. Such agreement merits great deference since they operate as both forum selection and the choice of law clauses and offer stability and predictability regardless of the vagaries of local laws.
Wow, that was a great discussion, everyone. And once again, I would like to thank all of you for giving insightful comments about the case and theories. Now I'm going back to the case study and talk about and give the decisions of should the U.S. court compel Steamship to submit to international arbitration. So the decision for this case study is yes, the standard for demonstrating arbitrability is not a high one. In fact, district court has little discretion to deny an arbitration motion. As with any other contracts, the parties' intentions control, but those intentions are generously construed as to issues of arbitrability. Therefore, the only issue properly before court is whether the parties entered into the contract that committed both sides to arbitrate the issues of the contract's validity. Where the parties have signed a document that contains an arbitration provision, as here, all questions regarding breach of agreement must be referred to arbitration. The elimination of all such uncertainties is indispensable. And it is an indispensable element in international trade, commerce, and contracting. Thus, the most minimal indication of the parties' intent to arbitrate must be given full effect, especially in international disputes. I believe that we have garnered a good understanding of Nicaragua and versus standard fruit and all the theories that comes with it. Expropriation. I thank you all so much for joining me here today, and I would like to give a special thanks to the International Business Law Academy and Dr. Sub.